Okay, Robert, what are we talking about tonight? What's on the menu? It's a big one. We got Chauvin. We have got, oh gosh, we got Chauvin. We got the NCAA. We've got cheerleaders who are going to the Supreme Court. Supreme Court doesn't have time to hear election lawsuits, but they can hear a cheerleader free speech issue, which is a very important one. Oh God, I'm going to forget the rest, but let's just start. I mean, everybody wants to know the latest updates in Chauvin. Spend a bit of time on that. Then I'm going to go discreetly look at my list and we'll get onto the others. Chauvin update. Okay, I mean, I guess the update now is we've actually had a few days of trial and we've had some meaningful witnesses and we've had some meaningful testimony. Chauvin's girlfriend, or not Chauvin, I'm sorry, George Floyd, the now deceased George Floyd's, I guess, his girlfriend, 2 EMTs, a sergeant who have testified. I guess to summarize the testimony, one of the sergeants said that the force Derek Chauvin applied to George Floyd was completely unnecessary. This, according to Sarah Sidner, was one of the great moments for the prosecution. The defense brought up the drug use, brought up the overdose, the near overdose a year back. One thing before we even get started, and I don't understand the impact of this, it was a tweet going around. The defense brought up the fact that George Floyd's girlfriend, her nickname was Momma. And I don't know why. I don't know if they were making fun. And if they're making fun, I don't care. Or I don't know if that had evidentiary relevance. Do you know if there was any reason for that?
It's that when Floyd kept crying out for his mama, they assumed it was for his mother. It turns out he may have been referencing his girlfriend. So okay. that it would explain, and it's a minor matter, but it would explain his mother himself. His mother was dead. So the question was why he was, calling out for mama. And now it makes more sense. It was because it was his girlfriend. Most likely that's what he meant. We can't know for sure, but that was the only no major evidentiary significance beyond that.
Okay, and that doesn't make it, as far as I'm concerned, doesn't make it more relevant or less tragic. That's crying out mama if it's for your girlfriend while you're in a state of distress is no less tragic and upsetting. What do you think is the biggest evidentiary revelations, I guess? They're not revelations, we've known them already, but that have been now formally adduced as evidence. What do you think the biggest ones are?
There may be a different culprit for George Floyd's death, and that culprit may be the drug dealer. So it turns out that the person in the car with George Floyd was his drug dealer, according to the testimony of his girlfriend. And there's evidence it appeared that he was... that he had used drugs before he went into the store, given his behavior in the store. There was interaction between he and the drug dealer in the store. What I suspect is that it may have been the case that he wasn't buying cigarettes for himself, that the drug dealer was like, I'll give you drugs if you'll pass these you pass these counterfeit bills to buy me things that I want. And that may explain why the drug dealer's in the store, but doesn't appear to buy anything, is watching Floyd buy something, and is with him in the car. So so a lot of this may be sort of on the drug dealer, but the main potential legal culpability is if according to the girlfriend's testimony, they didn't know they were being given fentanyl frequently by this guy. That they didn't know what it was, but that it caused her to have major problems, him to have major problems. He had nearly overdosed a year before after suddenly ingesting drugs at a prior police arrest. But he had also nearly overdosed 2 months before, such that he spent 5 days in the hospital. And she later learned that it was heroin or something like that was in his system. And fentanyl is something people use that are trying to get off of heroin. Though they usually don't intend to use fentanyl. They use some opioid that is just laced with a heavy level of fentanyl. And the question is, did the drug dealer... so that would also explain why Floyd is so nervous when the cops come. He has his drug dealer in the car with him who likely has drugs on him. The drug dealer may have been the one in part who wanted him to ingest those drugs suddenly so that there was because the drug dealer could get in much bigger trouble because it would lead to much bigger problems for him.
And actually, to stop you there, so from what I understand, the drug dealer's name, I'm going to forget it if you remember it, but he's the one now, Morris, I think, he's the one who has now announced that he would take the fifth if he were called to testify. So they made a motion to quash his subpoena.
Correct. He lawyered up, pretty smart. He had been talking about, all this had been hidden by the press and by the prosecutors. They had not disclosed this to anybody. Instead, the news was that this guy was going to be George Floyd's voice. He was going to be a very effective witness at trial. Nothing about him being the drug dealer. and it appears they knew all along. Not only that, the history of, if people don't know about fentanyl abuse, many of the people who take fentanyl don't realize that either that fentanyl's even in it or the level of fentanyl that's in it. And that a lot of those are considered accidental overdoses because they don't realize what they're receiving. And so the first question would be, did the drug dealer sort of create this whole problem by having Floyd pass the counterfeit note and the rest? And the second, and by then encouraging him, incentivizing him to ingest the drug suddenly so that it's not found on either one of them. But whether or not he gave him something that Floyd thought was different than what he was ingesting. And frankly, that probably fits the definition of reckless homicide. And the police, rather than investigate that, the prosecutors, rather than pursue it, if we had an honest investigative press, rather than inquire about it, kept it all a secret until it came out at trial when the girlfriend was testifying. And so that I've seen comments by Rosanna Arquette and a lot of people. This is a classic version of motivated reasoning. If you want to see how powerful it is and understand why jurors make up their mind early and bend the evidence to fit their preordained theory, just look at Twitter or social media, anyone else. No matter what happens or the mainstream press, no matter what happens, they only spin the story to be hurtful to Chauvin and support their narrative. They bury anything that counteracts their narrative.
Well,
I was talking to my brother-in-law who didn't know about any of this and was shocked by the details of it. And he's someone who relatively follows the story because he's been the victim of racial targeting by police in the past himself. So, he can relate to that part of the George Floyd story as presented by the press, not knowing that there's this whole other story, not only about whether or not the sudden ingestion of drugs caused the death, but maybe the drug dealer encouraged him to do it, helped create the whole setting for it to happen, and gave him something he didn't know what it was. A lot of the fentanyl overdoses are accidental overdoses where they don't know it's laced with as much fentanyl as it is. And given the girlfriend's testimony, she provided further evidence for that this drug dealer was constantly giving them something that was different than what they thought they were getting. And so but it's astounding. But that narrative doesn't fit anybody's narrative from the press or the police or the prosecutor's position.
You have Chelsea Handler on Twitter saying, why do we even need a trial? We have video. I was like, now this is an interesting thing because, and it goes back to the video I did the other day where, I know what I thought at the beginning, like when all we knew was what the media was reporting. I know what I thought. And I played the game at the time. I said, well, what would I have to learn in terms of additional information to change what I think right now? And I said, I don't care what George Floyd said to Chauvin beforehand. I don't care I don't care what occurred beforehand. What I saw in that video, what could change my mind in terms of the consequences following from what I saw in that video. And, people are going to call me biased or just, stubborn. I'm clinging to my initial reaction. I have now, if I'm a jury member and I learn what I know now compared to what I thought I knew then or my initial reaction, my mind is somewhat more open now to what is arguably the overcharges. They're charging him with something now given the information, I can see it becoming increasingly difficult to prove beyond a reasonable doubt. Whether or not I think, what other lesser crimes Chauvin might be guilty of. I don't know what lesser, like excessive force, assault, whatever, what they're charging him with now. Given what I knew then, I said a few things were going to change my mind back then. Knowing that he might very well, knowing all this, you'd have to have a closed mind to not say there might be, you may still think Chauvin is guilty of everything, but you'd have to have a closed mind to say this is not going to raise a reasonable doubt. Now, Nick Ricade on his channel saying, it doesn't matter if he were about to pass away in 10 minutes. If what Chauvin did caused him to pass away in 5 minutes, you've nonetheless robbed someone of 5 minutes of their otherwise short lifespan that's remaining. So, what's going to be the argument to counter that?
Well, the legal factor is substantial factor. So was it a substantial factor in his death? And that's sort of a separate analysis from what his intent level was and what the elements of the crime were. So they could have charged him with just assault, and they would have gotten almost guaranteed conviction. They didn't because they want to force the jury to convict him of murder. They could have accepted a plea deal where he would have done about 10 to 20 years in state prison. They didn't because they want to convict him of counts that simply don't fit. It is I refer to it, I was on the gaggle with George Samueli, which people can watch. And I said, this is really a Soviet-style show trial because so much of the trial is not about the facts or the law. It's a show for the media and for public consumption. And part of that is the overcharging. And it's not just me who believes this is overcharging. Dershowitz has said the top 2 counts simply don't fit, period. And he's been a strong Chauvin critic. Mark Garagos, who I've been critical of otherwise, comes from a very, very different perspective than me. He's referred to it as a show trial. Norm Pattis, who I've had some disagreements with in the past, he's from the left. He referred to it as a show trial. So you're seeing more anybody experienced in criminal defense and that's willing to be honest. Now, many are not. Garagos reported that the press can't not even find defense lawyers to give a defense perspective in the court of public opinion on this case.
Yeah, I mean, we saw Sarah Sidner, her reporting where it's like you're going in on Team Floyd and reporting only on beneficial stuff to prosecution and utterly ignoring the good points the defense raises, which, like I said in my video, is going to create an expectation where people might face a result. They're going to say, well, how did this happen? I didn't hear the CNN reporting on any of the other stuff. And it does a disservice to everybody. But okay, now getting back to something that Nate and I have been talking about, the felony murder charge. So apparently the felony murder in Minneapolis is very different in that in order to get to felony murder, all you have to do is prove the underlying felony and it's strict liability in terms of resulting in the death, and in which case you get felony murder. So even if you were able to get, easy conviction on assault would be a felony, I imagine, leading to death. Why would you not necessarily get to felony murder in any event?
This is why. Felony murder is supposed to be a completely separate felony from the murder. By that definition that people are pushing for felony murder, every single murder is by definition felony murder. Name me a single murder you can commit without also committing an assault.
No, I think you mean every manslaughter would necessarily be felony murder.
No, felony murder is felony murder. What I mean is felony murder is supposed to be where you're you're doing a separate felony that's so inherently dangerous, usually to a wide group of people, that that if a death happens, you're responsible for felony murder. There's been a lot of criticism of felony murder over time because if people see how it's applied, sometimes it's absurd in its application. But
can I stop that aside? Nate gave us an example during a stream with Eric Hunley. Check him out, by the way, on Locals and on YouTube, where he said sometimes in let's just say a bank robbery, a cop kills one of the assailants, one of the perpetrators. The other perp can get convicted of felony murder because his co-perpetrator was killed by the cop. Is that an absurd example?
Oh, yes, and that's happened. And the idea is if you commit a certain inherently dangerous crime that has a real high risk of death attached to it, then that's where it's a separate kind of crime. Then if a death happens, you're going to be considered felony murder culpable. That has usually been bank robberies, kidnappings, terror type events, things like that. It is almost as Dershowitz said, it makes no sense. If every single assault can be charged as felony murder when a death results from the assault, then every single murder can be charged as felony murder. There's no murder you can't commit without committing also an assault. So that makes zero sense. It's not supposed to be a lesser included. Right? That's not what's supposed to be. It's supposed to be a totally separate crime with its own separate elements. And to give you an example, in Minnesota, to make this clear, they specifically said drive-by shootings cannot count as felony murder, and that sexual assault that leads to death cannot count as felony murder. So they were making the point, we don't want someone trying to commit the murder to be charged with felony murder. You either get charged with intentional murder, reckless murder, or manslaughter, but not felony murder unless it's a separately inherently dangerous felony that we want to punish you when death is the consequence of you committing that inherently dangerous felony that wasn't intended to kill someone. It was intended to do something else. So that's why this is what Dershowitz said. Almost every self-respecting criminal defense lawyer has admitted this. Almost no one will go on and say this makes sense for felony murder. Most of them keep their mouths shut. Well,
I pulled up Nate's message here, which he knows how to spell. I think he's just angry and putting it in caps. He's not angry either. He's typing fast. Tell Barnes there is no merger doctrine in Minnesota. I'm not saying Minneapolis. In Minnesota, the complaint says the underlying crime is assault.
Makes no sense, because by that definition, and can Nate tell me a single murder you could charge that wouldn't also be felony murder? Name one. How could you commit a single murder without also committing assault? You can't. There's no way to do it. I've even tried to think it through. I've been asking other lawyers, like, name one. Nobody can name one. Well, then what's the point? Why have a separate felony murder charge if every single death, a homicide, can be charged as felony murder? Well, why exempt sexual assault that can lead to murder? Why exempt drive-by shootings that can lead to murder from the felony murder statute? That's why it makes zero sense.
Now, but is this argument, or I don't know if it would be the question of the constitutionality of this provision of law, is this at issue now, or at any point will it be during this trial?
Oh, yeah. I mean, they moved to dismiss on these grounds, and the judge's excuse for it was not a strong argument at all. He got some basic stuff confused. And so far, no one has pointed to me a single example where somebody killed somebody and they were charged with felony murder, where the only underlying felony was the assault that led to their murder. I mean, that I've seen zero examples so far in Minnesota or anywhere else.
Yeah, and incidentally, sorry, take that out. One of the examples that a lot of people were referring to, apparently I think it was, I don't want to make a mistake on the name of the case, but the underlying felony was actually burglary and not the assault itself. So
right. It's those kind of things. You do something that inherently creates an undue risk of death. You're going to be responsible, no matter why the death comes about. You're going to be responsible if the death happens during the commission of that crime. So that's the whole, if you understand, this is why Dershowitz was like, this is absurd. The felony murder doesn't fit. And again, he's a harsh Chauvin critic. So the other people that looked at this said this doesn't make sense. So so I think legally it doesn't fit at all. They're going to be given questionable instructions, so it's going to be a question on appeal. But again, this is what Garagos was pointing out. He was saying all these people that are cheering this are making some of the most dangerous precedents they've ever met. And it's coming from a lot of the lefty criminal defense crowd. He's like, think long and hard before you get excited about this method of evidentiary presentation. Think long and hard before you want these kind of laws elastically expanded like this, because they're coming for you next. You're going to be the number one victim of it. People, the constituencies and communities that you back on the criminal justice left, and that they're too blinded by the politics of it to do a Dershowitz style analysis. So the same problem with the third degree murder. The third degree is supposed to be so gross. My question to people is, tell me now, what's the difference between third degree murder and second degree manslaughter in Minnesota? Because as to this one, there's none. There's no difference in the definition of the elements now.
Well, I mean, depraved mind versus reckless act. I don't know how you could enact this.
Here's the thing: when you dig into depraved mind, they define it as the exact same way they define a reckless act. It's defined exactly the same now in Minnesota.
It's very interesting, because I mean, I'm reading through the charges. I don't understand how you can get to felony murder when
poisoning is an assault. Poisoning is absolutely an assault. People don't understand how broad assault is. It's any invasion of a person's body by some physical means. It doesn't have to be direct. So it doesn't have to be punching them in the face or hitting them. That's what I'm saying. Find a way you can murder someone without assaulting them. Like, let's say you attempted poisoning, you didn't kill them, you didn't even attempt to kill them. The poison was something to make them sick. You can be charged with assault. It happens all the time. So that's why people have, it'll be a good, maybe someone can find me. Maybe they can trip up the Barnes. If they find it, God bless you. I'll pin your tweet on Locals. VivaBarnesLaw.locals.com.
So someone asks here, how can they charge felony murder based on assault when he isn't even when he's in charge or convicted of assault?
Because they don't want the jury to have the option of assault. But it's a problem because it's a lesser included. Felony murder is not supposed to have a lesser included. So that defeats the point of the purpose.
But okay, is lesser and included in manslaughter assault as well?
No. Manslaughter is you just engage in reckless conduct that causes someone's death. That doesn't require an assault.
So there is
but
no.
It almost always probably would. I don't know many circumstances where it wouldn't, but it doesn't. But even there, that's not a problem. Felony murder is so distinct. It's supposed to be a unique kind of felony that's separate and distinguishable from the murder. Otherwise, like I said, every murder is felony murder. You can charge every murder now with felony murder in Minnesota if this precedent holds. Felony murder has a 40-year prison sentence. The point is we're supposed to have these different degrees of culpability and different degrees of sentencing in proportion to that different degree of culpability. Not in Minnesota anymore.
Well, I'm bringing this up because Ed Snowden, people are going to rid me as though they've somehow found a gotcha that I'm biased and they can write me off as biased. I'm disclosing my opinion on this, not to try to prove a point, but to let you know that this is my framework so you can assess what I'm saying. I'm giving as much of an analysis of everything as I would otherwise, regardless of how I feel about it. But I'm telling you that, Ed, I said it from the beginning. When I see someone kneeling on an unresponsive person's back for 3 to 4 minutes after they've stopped being responsive while they're handcuffed, yeah, I think something's wrong there. Now, admittedly, at the beginning, I thought something totally different in terms of, causality and absence of other potentially contributing factors that could raise a reasonable doubt in a jury. Do I still think that there's something problematic and dare I say, potentially lesser crime, but criminal about a police officer maintaining some form of position on an individual who is handcuffed and unresponsive for over 3 or 4 minutes? Yeah, I think that's a problem. I don't know what the statutes are. I don't know if there's a failure to administer aid, if there's assault. I don't know what that could qualify as. But regardless of whether or not Chauvin was the determinate cause of death, or where there's reasonable doubt as to whether or not he was, I consider that behavior for a police officer to maintain that position on a handcuffed individual who is on his belly and unresponsive for 3 to 4 minutes. I consider that problematic. You can call me biased. It's not going to change my analysis on the rest, but I think it's good for you to know my position at the very least on that. So as a question of transparency, not as a question of trying to tell you that he's guilty of something. I'm just telling you, that's what I think. I saw the video and now I know these additional facts and can see how this can raise a reasonable doubt on the charges that he's charged with, which is part and parcel of the problem as far as, most people are concerned.
And I think and that's always going to be the biggest hurdle for the defense, because it's far from clear that is consistent with his training, though the training doesn't appear to me to be crystal clear either. Now, in terms of the evidentiary presentation, this has been the prosecution. I got the book Reptile behind me. It's about the reptile brains, written by 2 prominent plaintiffs' lawyers. And the reason I'm recommending it is emotion sells. Scott Adams makes this point repeatedly. The myth of lawyers is that we're taught to think like a lawyer. And what does that mean? It means to think about the law, think about the facts, be able to change your motivation to improve your reasoning by changing which side of the aisle you have to be on in a particular mock trial or moot court or the actual practice of law. The reason why you have to be taught to think like a lawyer is because most human beings don't. Most human beings are not driven by mathematical, deductive, and inductive reasoning. We all like to think we are. But Eric Hunley on his Unstructured podcast, which you can find at unstructured.locals.com, they had Chase Hughes. I was almost blanked on his last name, but Chase Hughes on, and on the back of he described that almost all of our decisions, 90% of our decisions, are made by the sort of back of our brain that's not really conscious. That's what they're describing in the reptile brain. That's based on a wide range of survivalist techniques, and then our neocortex rationalizes that decision. But that's why I say motivation is the master of reason. Reason ain't the master of motivation. So if you want to improve your reasoning, change your motivation in a circumstance or situation. But normal people don't. And the prosecution went with a emotional, visual approach. That's a second lesson people should know in general in life. Be visual. To give you an example, Robert Grueller, also on Locals, watchingthewatchers.locals.com. He's been doing a lot of good daily analysis and updates of the trial, so people can find that each day if you want a sort of a concise digest summary that includes clips from the actual trial and his analysis of it. But he gave an example of of how to be visual. He said what the defense, he said the prosecution wants you to see the case. Actually, I'll steal the little thing he sent me as a gift, watching the Watchers, one of these. It's like the prosecution wants you to look at only one little piece, and he visualized it like this. And the defense wants you to broaden your scope and see the context. Now, that's a good visual reference. Unfortunately, the defense lawyer didn't give one. To give an example, in the Snipes case, that was a 2-week trial. Now, it's a federal trial, so those go longer, but it's still half the length of this trial in terms of duration. And we gave 3-hour opening statements each. The defense gave a 20-minute opening statement. Massive mistake. And the reason why, with almost no visuals at all, while the prosecution, they were also short. I would have had that jury crying if I gave the prosecution. They would have been tying the knot, ready to go, asking where the platform was. He did decent, but he used visual references. For example, they used a chart. Most of the prosecution we previewed before it even gave the opening statement. They gave almost exactly what we talked about. They just could have used more emotionally impactful language, in my view, but that's another story. But they did a chart, and here's where they genius. They did a timeline. Always do a timeline. It's always good. They did a timeline where they managed to have one photo on it 7 different times in the timeline. Take a wild guess what that photo was. It's the photo of Chauvin on the neck of Floyd. They managed, it was kind of subtle, but not so subtle at the same time. But so they're locking into people's brains every piece of time with that photo over and over and over and over. They use good language. They said, the police badge is a small badge, but with it comes big power and big responsibility with that power. They had some, good phraseology throughout that if someone's in your custody, they're in your care. Good little lines like that. And so it was pretty well done. Not as well done as it could have been, but above average for prosecutors by far. Then the defense came up and did a 20-minute linear police report style defense. And there was some good utility to it from a framing perspective. He said, let's look at the 4 pieces of evidence, the 4 places where you're going to see evidence: the store, the Mercedes, the squad car, the hospital. It was smart. It was very subtle, but smart to throw in Mercedes. That's what George Floyd was in. And because that's creating a different impression of Floyd, right? It's not creating the impression of Floyd in a poor person's car or something like that. It's Floyd in a Mercedes. The nice, subtle thing he did. But otherwise, it was too lit. But it's the way we're taught as lawyers. Think rationally. Think in terms of evidence. Think in terms of deductive, inductive reasoning. Think in terms of law. That's not what sells with juries historically. What sells with juries is emotion, 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 and their survival instinct. And so that's what the prosecution. And then, even Garagos and other people were saying it was outrageous how emotionally pitched this trial was. Some different defense lawyers are saying this is unsettling. This is a bad precedent to set. You're not supposed to put up witness after witness after. They had 8 witnesses, I think, cry on the stand. They had fire workers cry on the stand, sergeants. They had young kids, older people, middle-aged people, men, women, all just cry, 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 cry. How these people feel is not really that relevant. It's potentially relevant to sentencing, and that has to be determined by a jury in Minnesota. But that's really abusing it, and it seems like just getting a read on it, which is difficult. But it looked like the judge was uncomfortable with the scope of this. But from a trial presentation perspective, it's very, very smart. They just saturated that jury in emotion from every different life perspective that could possibly be presented. From the most sympathetic, for the most part, there were some people that weren't. The MMA fighter wasn't that sympathetic because it was obvious how hostile he was, and the fire worker lady was not that sympathetic because she contradicted her own testimony about what she would do if she was in Chauvin's shoes as a fire worker. But the others were little girls crying on the stand, old nice gentlemen who say, "Oh, I'm just nosy," came across friendly. I'm just your nosy neighbor, likes to look at stuff, crying on the stand. That's what the case has been. It's a Soviet-style show trial, and it's becoming increasingly a disgrace if you care about American criminal justice. And I think the defense, and now to his credit, defense lawyer is an excellent cross-examiner. I was going
to say that because people have to appreciate how hard it is for the defense attorney who has to cross-examine the girlfriend of the deceased victim in this, and you have to be aggressive, you have to be mean, but you can't look like you're being aggressive or mean as if you are giving the girlfriend of the deceased a hard time. And so he's walking a thin line when he does it, or a fine line when he does it. He's doing it pretty well. He got her to admit certain things. I think the pet name comment came out badly, but I think he did well enough with it to bring out that element and to get into the drug issues and to bring up the past history of OD, which they were allowed to administer as evidence. He's doing good. He looks a little good. He looks like an uncomfortable sort of goofy teenager, which allows him to do his job better, because if he looks like an aggressive bully, it won't go well.
He's very experienced at cross-examination. That is quite evident, and very skilled at it. There's a lot of people who are very clumsy at it. So where I'm critical of the opening statement, but though, again, 90% of criminal defense lawyers would have done that, and he may know things I don't know. He may have focus grouped the case. He may have jury trialed the case. He may know that he's doing a different emotional pitch, saying, look, appealing to the jury's ego. You don't want to be inflamed by emotion. You want to make a decision based on calculated reasoning. And so let's lower the temperature and think just in terms of empirical evidence. And what does it's really a different kind of emotional pitch. That may be what he's trying. It's just, I thought it was a huge gamble. Also, lawyers have this illusion that jurors are just invested in the case and they're not going to make a decision, by golly, until after closing arguments are made. So they'll save a lot for closing arguments. They'll hide a lot of their key evidentiary reveals for cross-examination that they think might be undermined if they tell everybody in advance where they're going. That it just doesn't work that way. Just follow the people on Twitter who think he's guilty. Now, they've been utterly unaffected by anything that's happened.
I'm sure they're unaware. I'm just sure they're outright unaware. Now, the one thing, actually, I brought it up before, but let me take these three. There was a super chat from Nate that I think we have to get to before two specific questions. Okay, this is not it. George Floyd was okay. No, this is here. It is right here. Come on. The felony murder doctrine is properly applied when the underlying felony is aggravated assault. State v. Carson. Yada yada yada. Boom. Okay, we'll have to look into it. Screenshotted, Nate. We have to trust but verify here. But here's the question. A lot of people are talking about...
That means the felony murder statute makes no sense in Minnesota. That's what that means. That the felony murder statute makes no sense at all in Minnesota, because that means that they intended for assault to lead to felony murder, but not drive-by shooting to lead to felony murder, when they explicitly said that. Not sexual assault to lead to felony murder. Does that make any sense? It's like, okay, if you just beat up a person and it leads to their death, then you can get 40 years in prison. But if you also rape them, then you can't. Does that make sense to anyone? Does that really make sense? So the logic of that, usually with those kind of cases, involve a case where the person's not trying to kill them, not trying to murder them, like it's a bar fight with 5 or 6 people and somebody ends up dead, something like that. That's usually, it's supposed to be a separate felony that's not just an underlying lesser included of felony murder. Otherwise, it just doesn't, like I said, doesn't make sense. Every murder could be charged as felony murder. I mean, every assault could be charged as felony murder. And then why even have other murder statutes? You're just wasting your time. Just charge all of them as felony murder.
I think that might be one of the criticisms. I just wonder if that's going to be the ultimate reality of Minnesota law. Question people are bringing up a lot, and it's a distinction that I think needs to be made. A lot of people are saying what Chauvin did was specifically permitted under MPD training manuals, to immobilize someone who's resisting, knee or foot on the back or the neck, wherever. And so what he did was okay. The distinction, from what I understand, is that that's okay up until the time where they are restrained in handcuffs. And at that point, the knee, the foot is supposed to come off. Some other people have been pointing out, no, there's a maximal restraint where you're allowed to keep it even after. And from what I understand, that's not exactly the case. Nate's in the chat and maybe can clarify this, but from what I understand, that's not the case if the individual has not been fully restrained, including the feet. So one way or the other, it was against MPD training manual for Chauvin to maintain that position after Floyd was restrained, and certainly after he was non-responsive. Now, the only question is then, if there are going to be proper charges, what would those be versus the charges that have been brought? That's a hypothetical that we may never know. Robert, I guess, okay, actually one question here. They could never now recharge him with a lesser crime because it would be too late?
I mean, well, they can, I don't know what Minnesota's procedures are. Usually you can always request a lesser included. It may not be in Chauvin's interest to do so. But it depends on the jurisdiction. Usually you can always request that at the time of the close of evidence. But I don't know if Minnesota's protocols, procedures allow that, or when they allow that to occur. There's a lot of dispute about what the training actually provided for and what the training actually was. One problem was now you combine a policeman with a politician, and you're going to have the biggest, most successful liars in the world. And I know some of my cop friends and cop folks won't necessarily, well, some of them actually totally appreciate that, because if you watch like a WWE film or any of those films, the cop on the beat is the hero. The people higher up are always the corrupt politicians, and that's because that's who they are. So they had one of those. They got a sergeant on the stand, but the sergeant wasn't really willing to be that critical of what took place. The lieutenant, he was eager. He was ready for TV, and he was ready to lie for the world to be promoted in prominence. And because this is a guy who's not a beat cop, this is a guy who sees an opportunity to rise up the food chain, to get promoted, to get hyped, to get celebrated. And there's a lot of those at the high-ranking positions in police departments. Unfortunately for the prosecution, there were two problems. One, he was so eager to lie that they had to interrupt him before he told too many dumb lies. So like the very first time they're asking him a question, he's like, boom, he's ready to turn to the jury and give it to him. Oh yeah, what he did was, I've never seen anything like that. That's never been approved. That's never been okay. That's clearly excessive. You can kill someone when you do that. But the first problem was it was too overbroad because the jury's going to see evidence that contradicts what he was trying to say. What the prosecution was trying to say was if this, and then if this, and if this, and if this, then that. He jumped the gun. If this, boom, he was off and running. And they had to try to bring him back, but they only partially did. The second problem is defense lawyers were saying, even on CBS this morning and other places, that there could be a motion for mistrial because he was not qualified as an expert witness. So what they did is they elicited expert witness testimony from someone who had not been qualified as an expert witness. And it was highly inflammatory, prejudicial testimony. It was something he was not qualified to give, hadn't been qualified in advance to give. Maybe theoretically he could be, but he's here the defense lawyer was sophisticated. He left at the right point, and the prosecution has done very well and stylistically and technically in their direct examination. They leave at the right point. They get a high point, they sit down. They don't drag it out. Defense lawyer's been doing the same thing. He's clinical in his defense, and he finished with basically, aren't you the tape guy? You're the guy who shows up and makes sure the tape is lined up right. And now you're an expert on use of force when you've been the tape guy for about 20 years, making the point this guy's nowhere near in a position to say the things he said. He also, remember, Minneapolis police originally lied to everybody and said they never approve of a neck restraint. No. They thought they apparently were unaware of way back archive. Like I say, everybody, never in writing, always in cash. But apparently these dimwits didn't understand that. And so ordinary sleuths in the internet found, hold on a second, that isn't what your training used to show. And of course, the jury will see a photo that was in the training by Minneapolis police recently that has a man already handcuffed and the guy still with his knee on the neck after he's handcuffed. Now, the question is the interpretation of some of that guidance, because it next says you should turn him over. But if you look at what position the photo chose with him turned over, he's no longer handcuffed. So it's not clear that second position relates to the first, given the visual imagery that's being taught. It seems to be something separate, something different. If you have this situation, you do this. If you have this situation, you do that. The clear defense line that the defense lawyer is pursuing is that Chauvin, because of the crowd, wanted to maintain control and didn't tie his feet together and then maybe flip him over, even though one officer recommended that because he thought it would even be worse for the crowd. He's like, I'll just stay here. Ambulance is on the way. Ambulance will show up, and so forth. So it appears, I don't think the evidence will show ultimately that Chauvin thought he was causing lethal harm or intended to. That doesn't mean they won't convict him anyway. But I do think there's an intent problem with the evidence presented so far. What they needed to say was every cop knew this is so reckless that you intended to kill him. And what the ultimate evidence, and that's what they sort of elicited from that lieutenant. But the actual evidence from what I've seen, and the reason why this gets confusing is there's different police training in different parts of the country. So there's police training in some parts in the world. Some places don't use the neck restraint. Some people do. Some states only use it for this purpose rather than that purpose. But I will say this. Here's why I knew the lieutenant was lying. He suggested that as soon as you handcuffed someone, you no longer needed to put any other restraint on them, even put them in the prone position. Well, just Google, find the number of deaths that have been found from a cop putting their knee on the neck. In Minneapolis, for example, there'd been over 200 uses of it. In the 5 years prior to this, no deaths. It wasn't unusual for them to go unconscious. That's where the non-responsive part wouldn't be a problem necessarily. 1 out of 5 times they would go unconscious, but that was seen as okay because you think they're on drugs, they're losing it, they're acting irrationally. If they just go unconscious, better off for them. And they even had a training mechanism to actually called it the unconscious neck restraint method in Minneapolis. But by comparison, Google, this is why I knew the lieutenant was lying. Google handcuffed person shoots police officer. Handcuffed person escapes. Handcuffed person kills somebody. It happens with disturbing regularity. You'll find lots of examples of it. So when that lieutenant said, "Oh no, as soon as they're handcuffed, you have nothing to fear anymore," he was lying. And I would have been a little more aggressive if I was a defense lawyer than that individual was. I think he was surprised. The prosecutor decided to sneak this in. And they're taking a lot of risk with this judge because the judge seemed irritated as well by the way he was cutting off the lieutenant. But they created a mistrial risk by what they did.
Well, the amazing thing is people who are not aware that these are practices employed, everywhere, that these are actual formal police policies as to or how to deal with individuals when detaining them. It'll be shocking to some. Just going to read a few chats that I want to get to. This is my last $5, so please read the chat. Could Chauvin have chosen the judge to decide the case instead of a jury? Answers yes. He could pick a trial by jury or judge.
Yeah, but the prosecution can refuse that.
And then what are they?
Both sides are entitled to a jury trial. So you'd have to have both sides waive their right to a jury trial to get a jury trial in most jurisdictions.
Very interesting. Now, someone else had asked, and this was a question I had when I heard the potential drug dealer was taking the fifth. Just dropped my phone. Can the defense not call him anyhow, even if all he's going to do is take the fifth to show what this individual is and what he has to hide in order to raise that element of doubt for the prosecution? Can they nonetheless call him, even if all he's going to do is plead the fifth?
Well, there was a high-profile example of that, a famous high-profile case where the lead police officer took the Fifth Amendment. The police officer who magically discovered all the evidence in the case, or almost all the evidence in the case, took the fifth. That was Mr. Mark Furman in the O.J. Simpson case. And they put him up for the purposes of cross-examining him and him just taking the fifth. Depends on the court. Some courts won't allow it. Some courts will, because the questions are not evidence. So and whether or not you can make an evidentiary inference from a Fifth Amendment assertion depends on the court and the circumstances. So that will be an open question as to whether they go that route or path. It was interesting. Once he developed it, I realized that he might have been planning on that all along. That he may be playing, like my view again goes to Thomas Mesereau. The jury wants a white hat and a black hat. Something bad happened. They want a white hat and a black hat. And I think he may be thinking, don't put the black hat on Floyd for suddenly ingesting a lot of drugs. Put the black hat on the drug dealer who didn't tell him what he was ingesting was so lethal. That would be a smart move. That'd be a surprise move. I didn't see it coming, didn't know anything about it, because that's an easy one for the jury to do. It's an easy one for the jury to say, I don't want to blame George Floyd because he died and I feel bad for him. And they played the violin on that. I mean, they played it with not only all the emotion, but putting up the girlfriend and how did you meet him? And he came over and he wanted to pray with me and so on and so forth. And, we had all this pain and that's the only reason why we took drugs and we were too poor to get drugs. It was very, very well done. Very, very well done. And I don't, by the way, I don't disbelieve any of her story. This would mean that they, in a civil case, try getting away with that. Most of the time, judges will not allow you to, in their view, play to the emotion of the jury overtly like that. I haven't seen and Grago said the same thing. Said he hadn't seen a case with that much just emotion after emotion after emotion. He's like, this is a dangerous pattern. He goes, people should think about it when their friend, family member, or community member is a criminal defendant next. Do you want all of that crying on the stand to take place? Because that usually leads to a lynching verdict, not based on reason, not based on evidence. So, but it was well done by the prosecution. But that would be a brilliant way to shift the black hat. Tom Mesereau was a genius of it. He was the guy who defended and got Michael Jackson acquitted. So if that's where he's going, then that will be impressive. Other than his opening statement, he's really been a very good defense lawyer. Not necessarily the greatest on the motion practice, but that's not uncommon. Your good evidence lawyers are rarely your good appeal lawyers. There's only a few of us who might fit that category.
And so what do we expect for the next week? Do we know who they're calling, what the order is?
Now it's going to be expert time. So emotion, visual. Now it's going to be the prosecution overloading the jury. This was why they took an unnecessary risk with the lieutenant. Just put up your use of force expert. You don't need to sneak it in with the lieutenant right before the jury goes home for the first weekend. I get it's tempting, but you created a real high risk of that being a mistrial. And with this judge, I wouldn't have taken that gamble with the prosecution because they're going to have a bunch of witnesses get up. Because the training was kind of vague, in my view, in Minnesota, and because like people can research this. The other thing, the reason why police officers do this, because I researched this years ago, I don't like it. I've been a critic of the spit mask. I've been a critic of even though they let those cops walk in Rochester related to it, I've been a critic of the neck hold. I understand why they do it. I just don't like a lot of these aggressively physical methods of restraint. I understand from the cop's perspective why it's often less risky than something else happening. But I just think it has too much risk to it. But I can say when I researched it, the evidence doesn't really support my assumption of risk. That the evidence is that the way in which the hold is done, there's very, very few incidents of it ever leading to death or severe bodily harm.
I brought up a comment from, I think it was Lone Wolf Ranger or something, says there haven't been 200 to 300 cases of someone doing it for 8 to 9 minutes. And
that's a fair point. Though there was one in Minnesota, or it was at least the 8th Circuit, where they had, he was under for 15 minutes and he died. And the cop and they said that could not, as a matter of law, be unreasonable force. And do you think that lieutenant who testified last week didn't know that? He knew he was lying. He was just happy. You could tell how eager he was. He's like, I'm getting promoted now, baby.
And that's the thing that, we discussed what precedential value other precedent will have, but people don't even know. There was another case recently it was in the instruction manual, 15 minutes. Now, apparently the distinction in that case, for everyone to know, it was 15 minutes to get the individual restrained. So it was not that the individual was restrained for however long and then
so he was restrained for, I think, at least a substantial time of that. His arms were at least restrained.
That's the thing, and I think it was like a full restraint because it was maximum restraint. There's a mild distinction that it was not as though the individual was unresponsive for 5 of the 15 minutes. Maybe for some a distinction without a difference, but most people don't know. 15 minutes in the same position led to death and acquittal, and the media is not going to report on that at all, even to prep people for the potential, because they want maximum shock and outrage based on maximum bias coverage, which is not going to reveal the strengths and weaknesses of both sides, because to reveal the strengths of the defense here would be traitorous to the tribalist politics that has now ingrained this case.
To the purpose of the show trial. And looking at it, and then the second problem is compounded here. So first is that if you're a police officer, the person becoming non-responsive would not be uncommon, in that 1 out of 5 people that the hold is used on would become unconscious. But there was no reporting, at least that I had seen in like almost 15 years in Minneapolis, of anyone being alleged to have died or suffered severe injury from it. The other component is the evidence here. The evidence here is no damage consistent with asphyxia. I mean, what the coroner originally said was, if you just brought this guy into me without giving me any other background, I would have concluded overdose, because he doesn't have any signs of damage here, no signs of damage here, no signs of damage to the ribs or others that would be indicative that the body compression is what caused his death. It appears that the coroner's at least adjusted theory after they had a nice little chat with him. That's why the state prosecutors for the county got kicked off the case, because they had that little chat. And I think the judge whiffed out what that was about. It was about them switching testimony. And I think it's more like the theory really is that the stress of the hold caused the death or contributed to the death, not that the neck hold restraint itself caused the death. But we'll see. That's at least how the coroner adjusted. But the whole medical profession is of the political mindset to lynch someone like Chauvin in a case like this, especially. So they have, in my view, cumulatively, they have 8 medical experts, 8 doctors that are going to testify. And they're going to have multiple use of force people. So all of next week is to bombard the jury that people in positions of authority say Chauvin guilty. People in position one after the other, after the other, after the other.
If I'm a jury member, that looks weaker than it does look strong to me. If it's a good point, you make it once, twice. I mean, the more you have, it almost looks like it's a weak point that you want to strengthen through an appeal to authority, kind of.
Yes.
And it looks like you also.
It often works. It often works. So, I mean, a lot of courts won't allow these cumulative experts. They've decided that the way they got around it is by their different experts in different parts of medicine. It's like, okay. So the cross-examination will be big, but the jury doesn't, I likely know yet, that the coroner's report is no physical signs of asphyxia. So the later positional asphyxia definition was based on pressure from the prosecution, and then all these more politicized doctors are willing to testify in a certain way. And so this will be the sign. How good his cross-examination will be critical for undermining the jurors' confidence in this, to the degree they're open-minded. Yeah, I'm skeptical of that, given what their answers were and given the venue that was selected prior to the jury, and given that I think he got behind the 8 ball with opening statement. Because what jurors actually do is they make a decision after opening statement and they start pre-filtering evidence. They do what the Twitter types do. The ones that want Chauvin to be guilty, they ignore evidence of acquittal, highlight evidence of guilt, and they keep doing it over and over. And you can't win them over. They're gone. And we're taught as lawyers that isn't the way people. The reason why we're taught to think like a lawyer is because almost no one else does. And lawyers underappreciate this in the trial context. So that's the other reason why I'm skeptical of it. But from otherwise, if this was a truly open-minded jury, the evidence has gone much more in the defense direction than the prosecution. So
that's what you have difficulty having a discussion with people who have already made up the mind. And why it's an impossible discussion to have on social media. Even Nate, who some people call the far left lawyer, say, this is not my opinion. This is just the evidence that's been presented. It's a tough thing. But we should move on because we've got a lot more to cover before this is over. I think we've done a good job summarizing for anybody who didn't watch the 3 or 4 days, 5 days. Geez, whoever didn't watch it, you've got pretty much all you need to know. And some of the details, you can argue over the details of, what the manuals say, what it means, because it's not black and white, even though it's written in black and white. This is the essence. So now you can go and you'll know more than the reporting you're getting from Sarah Sidner coming out of court, despite having prayed for her.